In contract law, there's something called the principle of mutual assent, which is also known as the meeting of the minds. It's all about the intentions of the parties when forming a contract. In terms of intent, when determining whether there is a valid contract, it's the outward manifestation of the party's intent that really matters. This is the heart of the case, Lucy v. Zehmer. On December 20th, 1952, two men got into a discussion about the sale of Ferguson Farm. This wasn't anything new to the two men. Lucy had given Zehmer multiple offers over the years, and in fact, about 7 to 8 years prior to this case, they had come to an oral agreement that Zehmer would sell the farm to Lucy for $20,000. In the end, however, Zehmer backed out of the deal. On this occasion, Lucy was offering Zehmer $50,000 for the farm, but Zehmer didn't believe Lucy really had that kind of money. So, the two drafted an agreement on the back of a restaurant check. Zehmer wanted Lucy to put his money where his mouth was, not really intending to sell the farm at all, while Lucy was serious about buying. On the check, Zehmer wrote, "I do hereby agree to sell to W.O. Lucy the Ferguson farm for $50,000 complete." Complete meant everything on the farm, which apparently was only 3 heifers. Lucy reconsidered, then realized it would be better if the language was changed to we instead of I, and if Mrs. Zehmer also signed. So the first draft was torn up and a new one drafted exactly the same, only this time with we. According to Mrs. Zehmer, she only signed this document because her husband assured her that this was only a joke and he wasn't intending on selling the farm at all. Lucy offered to give Zehmer $5 to seal the deal, but Zehmer refused to take the money. The two men testified that Zehmer said 2 different things. Lucy testified that Zehmer said, "You don't need to give me any money, you got the agreement there signed by the both of us." However, Zehmer testified, he said, "Hell no, that's the beer and liquor talking. I'm not going to sell you the farm. I have told you that too many times before." The next day, December 21st, 1952, Lucy called his brother, and the two got into an agreement that this brother would pay half the price and own half the interest in the property. On December 22nd, 1952, Lucy hired a lawyer to examine the property title, and the lawyer cleared it by the end of the year. On January 2nd, 1953, Lucy wrote a letter to Zehmer explaining that he now knew the title was good, so he was ready to pay in cash. He wanted to know when Zehmer would be ready to close the deal. It wasn't until January 13th that Zehmer replied that he never agreed or intended to sell the farm in the first place. It's a well-established rule of contract law that the outward expression of the parties determines intent. Outward expressions of intent can be reasonably relied upon when entering into contracts. Secret intents, however, are not reliable or reasonable. The parties involved cannot be inspected to read the other person's mind. So, could Lucy demand specific performance? Yes, because this was a valid contract. Why? Well, the court breaks it down into 3 distinct categories. 1. Zehmer had the capacity to contract. 2. The contract appears to be a serious business transaction. And 3. Lucy relied on the transaction. The court quickly dismissed Zehmer's arguments that he was too intoxicated and lacked capacity to contract that day. Lucy, Zehmer, and Mrs. Zehmer all made statements about drinking occurring that day, and witness testimony said they looked drunk. Upon looking at the check, Zehmer exclaimed, "Great balls of fire! I got Ferguson for Ferguson, and I got satisfactory spelled wrong. I don't recognize that writing." But in the end, the court doesn't really focus too much on the matter of capacity to contract. This is probably because even Zehmer's lawyer admitted in oral arguments that the evidence was clear that Zehmer had the capacity to contract. The court saw this contract as more of a serious business transaction than the casual, joking transaction that Zehmer wanted us to believe. In coming to this decision, the court looks at several different elements. For example, there was a 40-minute discussion between the two before the contract was written. Lucy objected to the first draft, and he wanted Mrs. Zehmer to sign the contract as well. There was a discussion as to what would be included in the sale. There was a provision for the examination of title. The contract was not only executed, it was signed by all parties, and Lucy took possession of the contract without any objection from the defendants to give it back. Even if Zehmer was joking, evidence shows that Lucy took the transaction seriously and considered it binding on all parties involved. For instance, he discussed with his brother to split the interest and the payment. He got a lawyer to examine the title. And, to be fair, before the contract was executed, Zehmer never told Lucy he wasn't serious about selling the farm. So, in the end, there appeared to be a good faith offer and a good faith acceptance. It wasn't until Zehmer rejected the $5 that there was any indication of it being a joke. So, what have we learned today? When it comes to legal documents, say what you mean and mean what you say. Before I go, I just want to let you know that I've written a detailed brief for this case. It's available on Mediafire. The link is in the description below. Thanks for watching.